Welcome to week 3. This week we're actually getting into a submission. We're getting finally to something beyond an overview and definitions, which I know everyone will be excited to do. And we're getting into something that I think is a little bit scary, and that's why I have this very shocked, horrified image. We're getting into GRAS, generally recognized as safe, a huge exemption to the Food Additives Amendment, ability to avoid a food additive petition, a submission that we'll get into in the weeks to follow. In the original syllabus, I had GRAS as two lectures separated, and I decided we're going to put them together. Here today, we're going to talk about GRAS generally, and then next week, we'll get into GRAS approval criteria and exactly how is a GRAS determination made. And I think it's scary both from a perspective as a regulatory professional, seeing how frequently GRAS is used, or really abused, and used in a way that allows products that maybe shouldn't be in intended use or level on the market. And also from a consumer perspective, seeing the FDA's inability really to manage its obligations under the Act. And we'll get into all of that in our discussion today. So before we can talk about GRAS, we have to remember that we are talking about the Food Additive Amendment. So in a very circuitous way, if you're not under the amendment, you're not GRAS, but if you're GRAS, you're not under the amendment. It's a weird phenomenon, but that's where we are. So as we talked about last week, we're here to talk about food additives, the primary control prior to the Food Additive Amendment, post-market. We're moving to a pre-market system. We're going to learn about all the additives before they hit the market. We're going to have a very good sense as the FDA about what's being used on the market. And we're going to do this in a way that gives consumer confidence and allows innovation. Ultimately, though, the goal was to shift the burden from proving a substance was adulterated and really the cost of that evaluation from the FDA to industry. And this was the intention. This was the idea in passing the Food Additive Amendment. And then as we'll talk about today, we sort of eviscerate that. We take away this idea of the FDA being continually involved in these substances before they hit the market. We allow innovation, but we weaken public confidence. We'll get into a lot of those concepts at the end of the lecture because the GRAS exemption means you don't have to notify the FDA, something we'll talk about. So again, we have to not only be under the Food Additive Amendment, and in this circuitous way, we have to say, are we a food additive? But then we're outside of the definition. And so we saw the definition is in 201S. We have direct additives, those that become a component or exercise an effect on food, and we have indirect additives. I wanted to provide the full definition, and actually this is still a bit truncated because we had subsequent amendments. So if you're under the pesticide residue amendment, if you're under the animal drug, if you're color additive, all these different amendments that came in, they're not included here, but they're also not part of the food additive definition. So we see everything here, and it says if you're a food additive, this is what it means. But if you're generally recognized as safe, then you're not considered to be a food additive. You're in the definition, you're in the amendment, but then immediately taken out. And so it's important to always start with this definition to understand, are you a direct additive, indirect additive, and are you covered by the amendment before you claim GRAS? It's always, always important to start there. And the concept of direct additives, pretty intuitive. We can think about a number of things that we would directly add to foods in making a particular product, or just as part of the process for stability, color, not for color actually, be careful there, for stability, preservatives, and other areas as well. But when we get into this idea of indirect additives, it's really important to define that concept and understand when your indirect additive could become a direct additive and how that changes the calculus. So we have this concept in the statute, but we don't have any definition to what it means to otherwise affect the food. You're not becoming a component, but you're otherwise affecting it. The FDA initially said that means zero tolerance policy. If you have something that touches a food product and there's a substance from that migrates is the word I would use now, but that wasn't necessarily the phrase that the FDA used. But if it went into the food product at any level, then it was indirect additive, zero tolerance policy. A lot of litigation ensued because of this, because you can imagine that this creates a lot of litigation about whether it's actually safe, whether the level is meaningful. If we're talking about de minimis migration, what are we talking about, and is it really a safety issue? And so courts created this concept of migration that's so familiar for anyone that works in this area. Does the substance migrate into the food, and at what levels? And a lot of court cases will talk about this idea. Monsanto had a case that was very famous that the court a bit admonished the FDA to say, hey, remember that you have enforcement discretion, that you can take this idea that if there's a de minimis amount of migration that's not truly meaningful for safety or any other purpose, that you don't have to always regulate this as an indirect additive and require approval or require GRAS determination. And as we'll get into, either way, if you were GRAS or food additive in the early days, that meant an FDA pre-approval. There was none of this self-affirmation we'll get into. So this really didn't work for industry. It didn't work for the FDA. The FDA is all about efficiency, the least cost approach possible, and going to court every time is not the least cost, not the most efficient. So we finally get a Code of Federal Regulations. We get a new rule, and there's the citation for you. And it adopted this de minimis idea. And if you're below 0.5 parts per billion in your migration, then the FDA's technically could act, but it's going to take enforcement discretion and not act on that level of indirect additive. So we went from a zero tolerance policy to a meaningful regulation that provides some uniformity. So again, we want to pause. We want to remember GRAS only applies to food additives. Look at the definition for indirect additives. Ask if it's being intentionally added. If there's an accident that occurs, there's some case law that talks about if it's accidentally you use the wrong plastic. There's a case where painters came in and their painting equipment got next to some food. That's something different. We're talking about intentional food additives, direct or indirect, as the case may be. And so if you're in the amendment by that definition, then you can go to the next question, which is to ask, okay, I think I'm a food additive. I think this substance is a food additive. Is it GRAS? So what was GRAS intended to do? It was initially really this idea about easing the burden for industry, for the FDA. The reading gets into that. We didn't want apples, lard, butter, coffee, all of these things that fit into this broad definition of food additive to be requiring a food additive petition every time a manufacturer wanted to use it. So really common substances, none of the novel chemicals that went through this process. It was the idea of creating a impermanent process. There was an idea that rather than grandfather all these substances that were in prior to the amendment, that there would be this GRAS that could change, that if new safety data, new questions arose, the GRAS could be revoked. It was not permanent. It provides several criteria for determining GRAS. We're going to get into that next week and talk about the approval criteria, but it's flexible in providing not only two options, but within those options how it works, and eventually even allowing foreign uses and some different foreign data, which increased the flexibility that wasn't there. Familiar to the FDA as well. It's always great when your regulators are familiar with how to implement a policy. We see GRAS, it's a different concept in the drug side, but it's there, generally recognized as safe and effective. Here we're not necessarily concerned about efficacy. We're not really concerned about whether it actually works as a preservative, as it works as a stabilizer. We just want to know that it's safe. So we had that concept in drug, as the reading mentions, and here the FDA felt that it made sense in the hearings to use it, and it would be something familiar to them. In addition, it narrows the focus. So rather than looking at food, which is this massive term that the FDA regulates, and then with food additives, they're given primary responsibility for determining additives in meat products. So truly, the entire umbrella of food falls on the shoulders of FDA to determine safety of these additives. And so that's a massive mandate. And if you can narrow that focus in and say we're going to not talk about some of these common elements. We're really going to focus on the novel elements, novel substances that are being used. It conserves agency resources, reduces the review time, which if you're in a pre-market stance, you can't use these substances until they're approved. And if the agency is overwhelmed and can't get to these petitions in a timely way, then that really creates an issue in industry. So that was another purpose of the GRAS exemption. So initially, following the passage of the amendment, the FDA did a partial list of GRAS items that we know are safe. They just have a history of use, and we'll get into how that's an approval criteria next week. Coffee, butter, lard, a lot are provided in the reading. All of those things that we don't think of as food additives, we think of more commonly as ingredients. You're adding it to the pie crust, you're adding it to whatever recipe you have, but that ingredient under the technical definition becomes a food additive. So the FDA is easing that burden, making a fast track process. You look and you see if you're on the list. It's a really big list now. Part 182, it's 6 or 7 categories that are in there that are listing by type. You can find things like chemical preservatives, nutrients, all these different categories. And even though a substance is listed in Part 182, and that provides you an ability to fast track by not doing a GRAS determination, still be very careful. There's no lesson that you get from my courses. It's the need for caution when reading and making sure that you're always looking at these provisions very closely. These GRAS listings state intended uses and state levels of use, and so you have to be very sensitive to sticking within those. Otherwise, the question becomes whether or not you actually have to demonstrate safety at that other level for that other intended use and get a GRAS determination. But if it's on there and it's in the level and intended use that's there, then it's a fast track. So the reading touched on this, and I wanted to make sure that we briefly looked at it. It's not as important as GRAS, but the prior sanctioned amendment. And as you can imagine, this passed in 1958, and what the FDA was attempting, Congress was attempting to allow the FDA to say, if you've given some facility, some manufacturer, the blessing, the authority to use this ingredient through a standard of identity, which listed the ingredient through an enforcement action that came to a resolution allowing the ingredient, whatever that would be, whatever that evidence would show, then it's going to be grandfathered in, and this will be something that you can use following the amendment. This happens in 1958, and as we go and keep coming down the years, we're now some 50-some years, 60-some years past the passage of the amendment. The likelihood of finding that prior sanction all of a sudden that you didn't have for the past 50 or 60 years, not likely to happen. So it's really fallen to the wayside. And even if all of a sudden you said, hey, I think this had a prior sanction, I'm going to use it, the ability to prove that is very difficult. But there is a partial list of what is given this prior sanctioned approval. A lot of it is what goes into paper products, and hence the image here, and that's alluded to in the reading as well. So it's out there. It's something that may come into play, but GRAS, clearly, I'm sure if you're familiar with this element of industry, you know how important GRAS is, and you may not have heard of prior sanction because it just isn't that big of a player. I like this game show image because I always get the question, do I do a FDA notification? Do I do a self-affirmation? You know, it's like, what's behind door number 1? What's behind door number 2? And, you know, it's great to have that option now. Prior to 1997, the FDA, you know, again, this idea of a very strict control mindset, zero tolerance policy for indirect additives, and here saying every GRAS determination must be evaluated by the FDA to assure that the determination is adequate for the intended use, for the level and the safety data that's there. All those things we'll get into next week. And as one can imagine, this truly overwhelmed the agency. The reading alludes to that, and there's some material on the FDA's website that talks about that as well. A lot of what the FDA was receiving was indirect additives that were migrating at a certain level. The indirect regulation helped with that, but ultimately the FDA decided it needed to have a self-affirmation policy. And so now that's allowed. You can do the same determination, and that's what's important. It needs to be the same GRAS determination. All that approval criteria we'll get into next week, all that documentation, it's essentially creating that same petition that you would normally have had to hand to the FDA for review, but now you keep on file and you say, we've reviewed it, we've made the determination based on the approval criteria, and we believe as a facility that this is an adequate GRAS determination. And you have that in the event of an FDA inspection or some other action where the FDA may ask for that. And typically, again, post-market, you're already using the additive. Alternatively, if you want that assurance that you're going to use this new novel ingredient and you're not going to have the FDA come back and stop the use, you can submit the same notification that you would have on file for a self-affirmation to the FDA to have a review and determine whether the GRAS determination is adequate, whether it's incomplete, or whether it's inadequate. The risk, of course, is as you get the FDA involved in this decision and there's an adverse decision, there's something that says it's inadequate or incomplete, then you're in the position of not being able to use that added substance, that food additive, or you're required to go through the food additive petition process, which has a higher bar of proof to show and more FDA involvement to go through. So from a consumer standpoint, that risk sounds great because we want to develop the incentive for the facilities to ensure they're taking the time to develop adequate safety profiles for the substances. But then also we can imagine as consumers, and I want to emphasize it's always important to look at this from both angles, consumer and regulatory professional. And from a consumer standpoint, we can say, well, maybe that risk actually incentivizes companies not to submit, and does that create a risk? And that's definitely a valid concern, and it leads to the question, and it's a very fresh question to be asking, is the GRAS system broken? It was created in 1958. We can imagine all the technology that is in our consumer goods today that was not even fathomable in 1958. And as people inside the facilities and know how our modern food is made, we can imagine how the process is changed in the facility from today as it was 1958, not only in the process that's being used to make the food, but what's being included in the food. Shelf lives are incredibly different. Preservatives, ingredients, flavors, so much has changed. It really raises the question, is it time for GRAS 2.0? Do we need a change? And this wasn't something that came through in the Food Safety Modernization Act, FSMA, that passed in 2011. FSMA did not revise, repeal, or change the food additive amendment. It did nothing in that area. And so the question is, do we need a GRAS 2.0? Is GRAS keeping the public safe, which is ultimately what the purpose of the FDA is for? And if we're being really honest about what the central core concern of facilities producing food is, it's the protection of consumers in order to protect the brand. And if we have a negative adverse event that gets a lot of media attention, not only is that a litigation risk for the potential illness, and we have that human element to it, not to just put it through a cost-benefit analysis, but that human element, and then dealing with those ramifications. So we have, as facilities, a vested interest in making sure that the public is safe. One example of this, and I included it in our readings, is the 2013 decision by the FDA to revoke the GRAS status of partially hydrogenated oils, trans fats. The question is, why did it receive GRAS approval in the first place? Why give it a safety approval if it later is shown to be unsafe? Was the scientific data not there? Has the scientific data grown? What's the purpose there? And how does that shed light into what the GRAS system is? I also included in the reading the new Pew Research. It produced a new report that I've included an excerpt in for our reading. The full report is actually really great to look at. And they've identified what they call systemic failures in the GRAS system, and they're as a organization pushing for revisions in the GRAS system. And this is a pretty damaging quote that they have right in their summary. saying that most of the chemicals that are used in food are not known or detected by the agency until there's a crisis. And if you remember our introduction material and even the introduction today, we talked about how the Food Additive Amendment and many of the amendments that came through the 1950 to 1960 process, where we got 5 or 6 of these alternate amendments, were in response to crisis. And the Food Additive Amendment passed because one of the questions that the House panel convened asked the FDA, how many chemicals are out on the market and what do you know about their safety? And the FDA didn't know. They had no sense of the number of chemicals or the safety of those chemicals. They only knew about, again, they only knew about these issues when they were presented in crisis, when someone got sick or more likely a group of people got sick from these chemical additives. So it sounds like deja vu, when we hear this from the Pew Research and we compare that to what we know about the passage of the 1958 amendment. So we'll carry this conversation away from the lecture where it's just me into the discussion board, and we'll talk about whether or not GRAS is safe, keeping the public safe, whether it's time for GRAS 2.0, and maybe even looking at some other countries' models for how that works. And so we'll do that in the discussion board, and that will be it for today. And what we'll jump into, regardless of what we conclude in the discussion board, we're still here with GRAS. It's not changing, at least eminently. And so we'll next week get into the GRAS approval process and all of that aspects of how we make a GRAS determination, either to privately affirm or to share with the FDA. So I encourage you to now jump into the discussion board.